Hi, and welcome back to this intellectual property class. In class 7, we're going to be talking about the concept of adequate written disclosure in relation to a patent application and ultimately to a patent document. So, what is the concept of adequate written disclosure? What's disclosure for? Well, it plays into the underlying purpose of patent protection. So, as you'll recall, as we discussed in earlier classes, the theory is, or the economic kind of prevailing theory of patent law's justification is that the reason we have patent law is one, to encourage marginal inventors to invest in the production of new inventions or discoveries. In other words, the idea is that we want people to be innovators and to invest their time and energy and resources in producing new inventions that are going to benefit the public. And we're concerned that if we don't give people an additional incentive, they won't make those kinds of investments of time and energy because they won't be able to adequately capitalize or adequately profit from the inventions that they generate, right? We're worried about free riding, right? We think that if we don't give people patent protection, they either won't invest in inventions or they'll keep their inventions secret, right? And that's where the written description requirement, adequate written description requirement, really comes in, right? It comes in the context of disclosure, because the purpose of patent law is not only to give inventors a reason to invest in producing new inventions, right? An incentive to invest in producing new inventions, but also to require them to disclose what they've invented to the public so the public can benefit and so that other inventors can build on their invention. So built into the patent system, we've got this recognition, this fundamental formal recognition that invention is comes through accretion. It comes from people building on previous inventions, as I believe it was Newton said. If I've seen farther, it's by standing on the shoulders of giants, right? Every person who invents something new does it by building on inventions that have been developed in the past. And those new inventions, those new innovations are possible if and only if, or at least they're assisted or aided if inventors are required to disclose the information and knowledge that they've generated so that other people can use it to produce further knock-on inventions. And the written description requirement is all about making that possible, all about really concretizing the requirement of patent law that if you want to get a patent, you have to disclose what it is that you've invented. And so it really starts out, right? The written description requirement in Section 112 of the Patent Act says the specification shall contain a written description of the invention and of the manner and process of making and using it. In other words, you have to disclose the nature of the invention itself. You have to tell the public what you've created, not just claim the new elements, right? You have to tell them about the actual invention itself, how it's accomplished, and how it's actually created and used. You can't just describe what it is that you want to own, right? And that really plays a dual purpose role, as it were, right? Because on one level, as I just said, right, it means that you have to tell the public what the invention is so that the public knows and understands and can use that information, those new ideas, those new discoveries to produce further innovations. In addition, it would be impossible for the patent examiner to determine whether or not you are entitled to the scope of the patent claims in the document without you providing enough disclosure to know what it is that you've actually invented. In other words, the written description is also there to help the patent examiner figure out what exactly it is that you're saying that you've done in order to determine whether or not to grant the patent and to provide an exclusive right in the claims in the patent document. Are there even which claims in the patent document are actually enabled by the written description itself? Okay, so what about enablement, right? The enablement requirement says that not only does the specification have to contain a written description, but it also has to do so in such full, clear, concise, and exact terms as to enable any person skilled in the art to which it pertains or which it is most nearly connected to make and use the same. In other words, the requirement isn't just to describe the invention, but also to say how to actually put it into practice, right? In other words, the idea is you can't just come up with the invention itself and kind of describe it in general terms. You actually, or at least in theory, have to give enough detail that a person reading the patent document, or rather a FOSITA, a person having ordinary skill in the art, would be able to use the patent document in order to realize the invention that has been claimed. Now, what does that mean in practice, right? That can be a little less clear, right? Does the patent document have to disclose and enable the entire product that's been invented, or only the elements of the product, or the ultimate whatever it is that's being produced, that are actually claimed within that particular patent itself, right? In other words, what exactly has to be described, what exactly has to be enabled, and what enablement actually means in practice can be a little bit harder to pin down. So I wanted to show you a short video and have you reflect briefly on whether or not you think enablement and description are, or rather disclosure and in the form of description and enablement, are present in the video. So take a look. Take a look at the video.
For a number of years now, work has been proceeding in order to bring perfection to the crudely conceived idea of a transmission that would not only supply inverse reactive current for use in unilateral phase detractors, but would also be capable of automatically synchronizing cardinal grammeters. Such an instrument is the turbo-encapulator. Now, basically, the only new principle involved is that instead of power being generated by the relative motion of conductors and fluxes, it is produced by the modal interaction of magneto-reluctance and capacitive directance. The original machine had a base plate of prefamulated amylite surmounted by a malleable logarithmic casing in such a way that the two spurving bearings were in a direct line with a panametric fan. The latter consisted simply of 6 hydrocoptic Marsal vanes, so fitted to the ambifacient lunar wane shaft that side fumbling was effectively prevented. The main winding was of the normal Lotus O delta type placed in panendermic semi-boloid slots of the stator, every 7th conductor being connected by a non-reversible Tremy pipe to the differential girdle spring on the up end of the grammets. The turbo-encapulator has now reached a high level of development, and it's being successfully used in the operation of novatrunnions. Moreover, whenever a fluorescent score motion is required, it may also be employed in conjunction with a drawn reciprocation ding alarm to reduce sinusoidal repleneration. It's not cheap, but I'm sure the government will buy it.
Well, so I hope it's obvious that that was a lot of gibberish in the form of a nominally scientific presentation. Obviously, that wouldn't constitute disclosure or enablement for the purpose of obtaining a patent application, because everything that the actor in the video was saying was total nonsense. And not only did they not actually describe what the device was or how it would work, in fact, it's totally unclear exactly what the device in question is even supposed to be. And the whole thing is just a parody of the kind of nonsense that you can see, or at least apparent nonsense that you can see in the context of many fields of scientific endeavor, at least on occasion, and certainly within the scope of patent law. Right? So the question then becomes, what are our expectations on a patent applicant? What do they actually have to do in practice? Right? What kind of burden are we, and should we, make of the disclosure and enablement requirements. And the theoretical burden is at least arguably considerably higher than the actual practical one, especially when it comes to the enablement requirement. In theory, the patent document is supposed to enable a FOSITA to realize what's described and claimed in a patent document. In practice, actually enabling the practicing of the invention in question would be arguably borderline malpractice, right? The idea is to disclose just enough to qualify for patentability and substantiate the patent claims without disclosing absolutely everything necessary to actually accomplish whatever the goals of the invention are. Of course, that can be a fine line to walk in many cases and something that might need to be negotiated with the patent examiner. And there are certain risks involved in insufficiently disclosing because to the extent that the patent document is not amendable at certain points, or certain elements of the patent document aren't amendable, right? Insufficient disclosure might actually doom the patent application from the get-go. So a lot of really technical potential concerns here. But I think a great example, or at least one example to think about in relation to our expectations of a patent document, right, is when we talk about disclosure and enablement, does that mean that the device in question has to actually work, right? In other words, what do we mean by disclosure? What do we mean by enablement? Does enablement mean disclosing in such a way, or does it necessarily mean disclosing in such a way that a FOSITA reading the patent document could actually make the invention in question work, and it could actually make the invention in question work now, as opposed to perhaps in the future, right? So for example, in the case of the famous Alexander Graham Bell telegraphy patent, right? Alexander Graham Bell disclosed the machine for communicating sound electronically over a wire over a distance. But at the time he submitted and obtained the patent, he'd actually never successfully achieved the transmission of sound over a distance. Now, he eventually did achieve the transmission of sound over a distance using the method essentially disclosed by the patent itself. Is it right to say, though, that the invention was enabled by a patent when it hadn't actually been achieved when the patent was granted? I mean, after all, it's perfectly possible that it could have turned out that the invention disclosed and supposedly enabled by Bell didn't actually work in practice at all, and that he was missing something really critical or fundamental about the invention in question, right? How is a patent examiner supposed to know in advance whether or not an invention can actually work? And if it turns out that the invention does work after the patent application has been submitted, should that be enough for the patent to issue, or should we expect a working version, or at least quasi-working version of the invention prior to submission of the application? Well, the court ultimately held that the Bell patent was valid. So actually accomplishing the patent invention prior to submission of the patent application turns out not to be necessary. There might be a good reason to question whether that should be the case or not, right? Is that the right standard to use, or should we impose a higher standard of enablement, of like actual enablement in practice, as opposed to theoretical enablement if it happens to turn out that the invention in question actually works? So, there are circumstances where patents have not been valid because they didn't actually enable what they claimed at all. The casebook gives a great example of a patent claiming a method of using a chemical compound to block one enzyme but not another enzyme. Well, it turned out that was very useful, a good thing to be able to do, and something that actually turned out to be possible. Nevertheless, the patent in question was invalid because when the patent application was submitted, it was like a wish list, right? They were saying, we want to find a compound that will block one enzyme, but not another enzyme. But we haven't found one yet. We're hoping it's out there. Maybe not, but we think maybe. And if there is, it'd be really useful and effective. Well, the court said, no, you can't get a patent over a method of accomplishing something without actually having a path from A to C, right? There's a B there in the middle of what compound is it that's actually do this thing. It might very well have been possible that there was no compound that would do that thing, and then that would just be a dream and not a reality. And so even though they anticipated in this patent a method that turned out to be very useful indeed in creating pharmaceuticals to treat various kinds of ailments, they couldn't patent it because the disclosure of the patent document didn't actually provide anything in the way of enabling the claim that they wanted to own. Okay, then finally, we've also got the best mode requirement for patent protection. And essentially what that says is that the patent not only has to disclose the invention and enable the invention, but it also has to disclose the best way of accomplishing whatever the point of the invention is, at least insofar as it's understood at the time that the patent application is submitted. Now, the best mode or the best method of using the invention doesn't have to be specifically identified in the patent document. It just has to be included within the various ways of using the invention that are disclosed in the patent document, right? But it has to be there, right? At least insofar as it's understood at the time. If other uses come up later, that's not going to be fatal to the validity of the patent. And in addition, there's some question about how to determine what the best mode is. Should that be an objective standard or a subjective one? In other words, should it be what the inventor thinks the best way of using the invention is going to be, or should it be from the perspective of a kind of abstract fauxita? Like, what would most people in the field think the best way to use the invention is going to be? And at the end of the day, does it really make any difference? Hard to say, right? Key thing to think about in relation to the adequate written disclosure requirement. First off, right, the technical requirement is to adequately describe the invention. So at least theoretically, a fauxita or a person having ordinary skill in the art in question could actually carry out whatever it is that the invention is claiming. And the reason for the adequate written disclosure requirement is really fundamental to what we refer to as the patent quid pro quo. In other words, the idea behind the justification for patent protection is that providing those exclusive rights to inventors is justified because in exchange for getting those exclusive rights, the inventor has provided something more valuable than the rights they receive, namely exclusivity over what they're claiming, as well as the disclosure required by the adequate written disclosure requirement. So the disclosure is part of the quid pro quo, part of the value and justification of patent protection.